Thanks so much for joining me today. I have an interesting discussion which is a bit controversial in some people's minds. And the first thing to understand is that, a lot of people don't realize this, but I would say at least 90% of criminal defense counsel's work is actually negotiating resolution of cases where a client actually winds up pleading guilty or charges are withdrawn or getting peace bonds, etc. The average criminal case in Canada, when you receive it, I'm not talking about DUI cases, and I'm not talking about sexual assault cases, but most other criminal charges in Canada are not defendable. The police have very solid evidence and the person doesn't intend to go to court. Now, in sexual assault cases, they're usually always defendable. Not always, I shouldn't say that, but they're often defendable. Like 80% of the sexual assault cases we get are defendable. Impaired driving is becoming less defendable over time, although there's still defenses to impaired driving. The bottom line there is that Parliament's been tightening up defenses, but we still find ways to win those. But let's talk about resolution discussions, Crown resolution discussions, and what happens here. So when I get a file, I get the disclosure, I get the client's disclosure, and I understand and get all of the client's background. Hopefully they're a good previous character. Hopefully they've never had a criminal conviction before. And I'm looking at the case and I say to the client says to me, Mike, I'm guilty. I just want the best possible result. And I said, well, there's some weaknesses in the Crown case. You could go to trial. No, I don't want to do that. Well, what I can do is I can use the weaknesses in the Crown case to start discussing and negotiating with the Crown. Look, I've got a good client here. This is a fraud charge, but you don't have the best case in the world. There's an appropriate range of sentence for fraud. Maybe a range of sentence for fraud of that level, maybe it's a high level fraud, as an example, would be a 1 to 2 year sentence, just as an example. So because it's a weak case, the Crown may say to me, look, I can agree in that range, or even lower than 1 year, because the Crown thinks they have a reasonable chance of losing. So there's all these discussions that go on where, as a defense counsel, what you're doing is you're looking at the cost-benefit analysis of going to trial. What are my odds of winning a trial versus what is the Crown offering me to resolve this case? And in conjunction with your client, you're assessing things and saying, this is a great offer. It's up to you, but we've got a great joint submission offer where we can get a very low jail term for you, or no jail, or or conditional discharge, or it depends on the defense. So these discussions go on all the time. It's a lot of the work we do and any defense counsel does for all sorts of charges. Domestic assault is a prime example. We're always negotiating, hopefully, to avoid a criminal record on more minor charges. A lot of DUI still go to trial, though, but we're often negotiating sometimes to drop the charges because they're so weak. Careless driving, we get a lot of time. So we're always having these meetings with the Crown. We're reviewing the whole file, the client's background. Sometimes we're getting psychiatric reports from the client, counseling reports, employer letters. All this stuff has to be presented. And sometimes we'll then go on to a Crown pretrial, or I should say a judicial pretrial, where we meet with the judge to approve the deal. I think the pejorative or term of that people don't like and use is plea bargaining in the States, but it's not really that. This is a proper negotiated sentence. I mean, the Crown's got a weak case. The Crown knows that they should offer this. If all of these cases went to trial, our system would totally collapse. We have to resolve cases properly. We have to resolve them in an appropriate range of sentence. And there's ranges of sentence for each matter. So for example, if there was a minor sexual assault involving, say, a buttock touching at a bar, that range of sentences, either very short jail, probably even no jail, maybe even a conditional discharge. We don't throw a person in jail for 2 years for that. And this applies to every criminal charge. And I don't know why the public gets a bad view of resolution discussions, because I know that the system would collapse. There's not enough judges to handle thousands of crimes going to trial because the Crown's asking for a life sentence, or the judge is going to give a life sentence on each one. That's not the way our system works. So that's a very big part of defense counsel's work. You have to understand how to negotiate properly. You have to understand, hopefully, which Crown to approach. By the way, in some cities you can't pick your Crown, in some cities you can. It's helpful if you know the local judges who to try and appear in front of. Again, in some cities we can't pick our judges. In others we might have some information to pick certain judges who are going to give a lighter deal. And really, I would say probably, well, for sexual assaults, I'm sure 60% or more, actually way higher than that, go to trial that come to us, probably 90%, because people never admit they're guilty, it seems, and some may be truthfully innocent for sure of sexual assault. Impaired driving, a very high percentage used to go to trial. Fewer are. We're resolving a lot of cases, but again, a little known fact, this is a huge percent of defense counsel work, is being able to intelligently and successfully negotiate the best possible outcome or result for your client. And oftentimes that results in dismissal or withdrawal of the charge because, if I get a weak case, I'm going to go to the Crown and say, look, you've got no case here. Look at this case. There's no reasonable prospect of conviction. That's the test. If I can convince the Crown there's no reasonable prospect of conviction, they're going to withdraw the charge. On a DUI, for example, if there's no reasonable prospect of conviction, they might offer a careless driving or withdraw the charge. Same for any other type of offense. So that's a short kind of trying to defend plea bargaining, if I might put it that way. Let's call it Crown resolution discussion. It's totally appropriate, it's valid, and you're just getting the appropriate sentence for this offender and for their particular background and for the strengths and weaknesses of this case and the gravity of the crime. We don't throw people in life sentences for a minor, which is serious, don't get me wrong, minor butter, they deserve to be punished for that, but it's not a life sentence, let me put it that way. So I'm just trying to deflect some of the criticism for our resolution discussion system, which is really actually working very well in Canada. And I just want to thank you for joining me today. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.